The defense is also trying to subpoena Kouri Richins' sister-in-law, the one that Kouri Richins attacked. The sister-in-law who's the executor of the estate. It's Tuesday, it's October 28th. Kouri Richins is accused of poisoning her husband in an attempted murder on February 14th, and then an ultimate fatality of her husband on March 3rd, 2022. Where are we today? Well, there have been lots of motions by the defense. Remember, the defense attorneys went, this witness is recanted. You must release her, and you must order the prosecution to turn over exculpatory evidence, and you must, all of the things. So the defense made numerous motions. We went through them, how the defense feels about this information, how I feel about this information is different. Do I think this information is the entire case is falling apart? Not just based on this, but do I think that if a witness changes their statement, the defense should know? Yes, they should. Do I think it's a change of statement that is hugely impactful? It depends on the jury. Is there a next court date? No, there's not. There's going to have to be one because there are a bunch of motions. So the first thing we're going to look at is the prosecutor's response to the order to compel. The defense says that the witness who sold fentanyl to the go-between who sold it to Kouri, he originally said, yes, I sold fentanyl to the other woman who sold it to Kouri. And then later he said, no, it was just Oxy or Roxy's. I didn't sell her fentanyl. And I didn't even know what I was saying to the police the first time because I was in withdrawals from fentanyl. So I didn't even know. And I wasn't selling that at that time. So I sold Oxy, not fentanyl. So the defense is saying this is huge and the prosecution didn't turn it over to us. And we only found out because we went and interviewed the witness. I think it's a change of witness statement. Do I see that as a recanted statement? No, I see it as a change of statement. He didn't say, I didn't sell anybody anything. He said, I sold the go-between narcotics. It was the other one. It wasn't that one. State's opposition to defendant's request for order compelling disclosure of exculpatory evidence. The state of Utah requests that the court deny defendant's request for order compelling disclosure of exculpatory evidence because there is no undisclosed exculpatory evidence. The state and its agents have met with Robert Crozier twice. First, two detectives interviewed him on May 4th, 2023 at the Davis County Jail. Kouri was arrested May 8th, 2023, so like 4 days before she was arrested. The state has provided a body cam video of that interview to the defense. Second, Chief Prosecutor Brad Bloodworth and Chief Investigator Travis Hopper met with Mr. Crozier on March 28th, 2025 to prepare him to testify. The state possesses no exculpatory evidence from that meeting to provide to the defense. Look, man, if the witness changed his statement or clarified his statement, just turn it over. Why are we fighting over this? Defense replied to state's opposition for defendant's request for order compelling disclosure of exculpatory evidence. In its opposition, the prosecution stated that the defense request should be denied because there is no undisclosed exculpatory evidence. It submitted 2 affidavits in support of their opposition. I think both of them were sealed, though there are also affidavits, I think, with their other response, and I think they went to both. So we will see affidavits that aren't sealed, but there were sealed affidavits as well. The state did not deny that they did not provide Crozier's statement that he never sold fentanyl, only OxyContin, to Carmen Luber, but rather determined that it was not exculpatory. This was not the state's determination to make. Unfortunately, it generally is the state's determination to make if it's exculpatory or not. Clearly, they say Crozier's statement recanting that he sold fentanyl is more than potentially exculpatory. There's the word, potentially. Yet it was not provided to the defense. Therefore, the state should be required to turn over all statements made by witnesses as stated above. Don't witness statements get turned over? Like what? If the witness statement is I'm available to testify on Wednesdays, not Thursdays, no. But if they're talking about the case, yes. We met with witness this day. We discussed their prior statement. They clarified this. I think that should be turned over. Therefore, the state should be required to turn over all statements made by witnesses as stated above, so the defense has all potentially exculpatory evidence prior to trial. It goes on to say further, the prosecution did not articulate any objection to the defense's standing order request. They didn't. They said that there's nothing to comply with. With no objection to the standing order, the defense requests that the court grant the motion for the standing order. Mr. Ramos is like, they didn't say no, grant it. State's opposition to defendant's motion to reconsider bail and conditions of release. The state of Utah requests the court deny the defendant's motion to reconsider bail and conditions of release because Robert Crozier's recent assertion that he, quote, understood that the pills he sold to CL contained only OxyContin does not amount to a material change in circumstance. I don't disagree. Regardless, substantial evidence exists to support the aggravated murder charge, notwithstanding Crozier's recent assertion. Crozier's recent assertion does not amount to a material change in circumstance because it is not credible. Regardless, it does not detract from the substantial evidence that the court has twice found capable of supporting a jury finding that defendant is guilty beyond a reasonable doubt. A reasonable jury could choose to completely discredit Crozier's recent assertion for the reasons stated above or assign it de minimis weight in comparison to the weight of the evidence well established in the record that defendant committed aggravated murder. At bottom, a reasonable jury could consider Crozier's recent assertion and still easily convict the defendant. Yeah, oh, I just thought I was selling her this. She asked for fentanyl, I was just giving her this. I mean, who knows what's in those pills anyway? Pills went from Crozier to CL to Kouri. And then the victim's toxicology report shows like 5 times a lethal dose of fentanyl in his system. Defendant's reply to state's opposition to defendant's motion to reconsider bail and conditions of release and request for a hearing. Quote, truth is not what you want it to be. It is what it is. And you must bend to its power or live a lie. I said the defense motions were getting too heavy-handed with the hyperbole. And they were just like, lean in more. The state has relied on only one of the corroborating witnesses, Mr. Robert Crozier, to testify that the pills provided to CL were in fact fentanyl. And the autopsy! He is the only witness who could potentially claim a direct connection between fentanyl and Ms. Richins. Other than the only other individuals in the house this evening were young children. I just disagree with the fundamental premise of the defense's argument. They are doing their job. The defense goes on to say, however, now that Crozier has stated under oath that he did not provide fentanyl to Ms. Luber, the state is asking the court to find that one of their most important witnesses is no longer credible. Although ultimately Crozier's credibility will be determined by a jury, at this stage, it is in the providence of the court to listen to Mr. Crozier and make that determination. This is a trial issue. This does not get them across the threshold for a change of bail. I don't think it's a change of circumstance. Notably, it is never the job of the prosecution to determine the credibility of a witness. The prosecution kind of has to determine the credibility of their witnesses when they decide to file a case. Like if they determine a witness is not credible, then that's the only witness. They need to make those determinations, but okay. The defense goes on to say not for the purposes of bail, nor for any other purpose. Should this court find Mr. Crozier's testimony to be credible, the weight of the evidence in this case will be significantly changed. I also disagree. From that which existed at the time of the last detention hearing in this matter. The elimination of the state's alleged link to fentanyl to the defendant is a material change in circumstances, and without it, the state can no longer claim the existence of substantial evidence sufficient to support a denial of bail. I just disagree. They go on to say because the state is now placing Mr. Crozier's credibility into question, the defense is requesting an in-person hearing to enable the court to observe Crozier's testimony and demeanor and to decide whether Mr. Crozier's credibility is sufficient to support Richins' claims that there is no longer substantial evidence to support a jury verdict of guilt. Such a finding would require the setting of bail as a matter of law. I don't think they're going to get the hearing. For the reasons stated herein and in Ms. Richins' motion to reconsider bail, the defendant respectfully requests that the court schedule a detention hearing as soon as practicable and release Ms. Richins on a combination of bail and conditions. I just don't see that happening. The defense is looking for more information from the former sister-in-law. This was filed back in June. The reason that the response just came in, and the response just came in last week, is because the case got stayed in between. This was filed right at the same time that the change of venue motion was going up on appeal. So it got paused till now. So let's go back in time to June to take a look at what the defense team is asking for from the sister-in-law. Katie was duly served a SDT in this matter by undersigned counsel for the defendant pursuant to Rule 14B of the Utah Rules of Criminal Procedure and Rule 45 of the Rules of Civil Procedure. Counsel for Katie timely responded and partially complied by producing various documents and videos. However, counsel objected and refused to comply with multiple requests contained in the subpoena. See attached. For purpose of this motion, the defense is seeking to compel compliance with the following specific requests. All documents in your possession or control showing the financial activities of the Eric Richins Living Trust dated November 3rd, 2020 from March 3rd, 2022 to present. In responding to this request, please provide all documentation showing trust liabilities, receipts, loans, disbursements, deposits, income, expenses, gifts, and payments of any kind made by the trust to any person or entity. Such documentation should also include all periodic bank statements for accounts owned by the trust or its successor trustee in her role as successor trustee, and should include documentation of any trust activity for trust assets held in any attorney's IOLTA trust accounts. Such documentation should also include tax returns, check stubs, deposit slips, check copies, ledgers, wire transfer confirmation, and any other electronic mechanism or application utilized by the trust. No, Kouri can go get the trust documents in the civil case when the civil case moves forward. I don't see how this is appropriate for the criminal case, because if they are seeking to argue the trust didn't even have all that much money anyway, it doesn't matter what was in the trust. It matters what Kouri thinks is in the trust. So I don't see how she's entitled to any of this. It goes on to say, any copies of checks drawn out of your personal or business checking accounts made payable to any individuals connected in any way to the investigation or prosecution of Kouri. Then the response from the attorneys. So this was from July 30th. Each of the subpoena's requests are vague and ambiguous. Depending on the true nature and scope of the subpoena, it potentially subjects Katie to undue burden or cost. Specifically, most of the requests are not limited by subject matter or time. Request number 1, for example, requests all emails, letters, text messages, personal or professional correspondence between Katie and 5 categories of individuals over a 3-year period. It's possible that Katie has communicated with those individuals regarding subjects that have nothing to do with Kouri Richins or the state's charges against her. Request number 2 seeks any written or recorded statements that Kouri made over a 5-year period. As written, that would include a broad and unwieldy universe of documents. Even something as innocuous and irrelevant as a Christmas card would technically be responsive. There is no legitimate justification to subject Katie to the burden of scouring for every single quote-unquote writing Kouri has shared with her over the past 5 years. Request numbers 3, 4, 5, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17 have similar subject matter and time problems, and each subjects Katie to an undue burden. The subpoena requests information not in Katie's possession, which again imposes undue burden on Katie and serves no other purpose than harassment. Request number 3, for example, requests recordings made by Todd G. and, quote, any other individual. For one thing, if Kouri would like recordings that Todd G. made, she can send, and has in fact already sent, a subpoena to them. For another thing, oh, counsel's getting into it now. Counsel's like, and for another matter, Katie has no way to identify which, quote, other individual Kouri has in mind. Even if she could, it's unreasonable to ask Katie to track down that unidentified individual, procure their surveillance footage, and then produce it. Requests 4, 9, 10, 11, 12, 13, 14, 15, 16, and 17 suffer from similar problems. Counsel says it seems fairly obvious that the subpoena seeks irrelevant information. For instance, Katie's communication with her or Eric's various lawyers have no bearing on whether Kouri murdered or attempted to murder Eric, and neither do Katie's communications with Kouri Wright. From what appears, the subpoena is little more than a blind fishing expedition through which Kouri aims to harass Katie and needlessly drive up legal fees. Because the defense is asking for a hearing on this, other than just sending the letter, Katie's attorney responded. And Katie's attorney is not happy at all. The estate attorney is clarifying now what the defense was insinuating. The defense was insinuating that Katie was like paying witnesses. The estate's attorney is saying these are her expert witnesses in the civil case. regarding the estate. Like you need a forensic accountant. These are expert witnesses. The motion intimates that there is some level of mystery or intrigue. Ooh, we love a good intrigue. Isn't that why we're here? Surrounding which individuals Katie has used as an expert witness. The attorney for Katie goes on to say, there is no intrigue. There is no mystery. If Katie's relationship with Todd G and Carrington and Throckmorton are quote unquote secrets, they are some of the worst kept secrets in the world. It is a well-known and undisputed fact that Todd G is Katie's retained expert. Kouri has known this because Katie transparently broadcast it to her for over 3 years. Carrington readily testified at Kouri's preliminary hearing, and Katie had previously paid her for expert accounting work. And Katie told Kouri in objecting to her subpoena that Throckmorton is a retained expert. Kouri does not need anything more to prove these facts. Yet without evidence or legal basis, Kouri believes that not only do these facts make those 3 individuals non-credible witnesses, but also that they give Kouri unfettered ability to pry into the trust in Katie's confidential finances. She is mistaken. Suspected quote-unquote bias is not a free pass to seize sensitive information. Neither does it excuse litigants from standard discovery constraints, things such as relevance, proportionality. Katie has produced to Kouri's criminal counsel all documents that are non-objectionable and discoverable. Kouri cannot have anything else. I mean, period. The court should award Katie fees that she incurred in opposing the motion. Under the circumstances, the rules both mandate and permit the court to impose sanctions against Kouri. Rule 45E1 requires a party who issues a subpoena to, quote, take reasonable steps to avoid imposing an undue burden or expense on the person subject to the subpoena. Where a party breaches that duty, the district court shall levy an appropriate sanction, which may include, but is not limited to, lost earnings and reasonable attorney's fees. Similarly, Rule 37, the rule under which Kouri should have but failed to seek relief, gives district courts discretion to award reasonable cost, expenses, and attorney's fees. Sanctions in the form of Katie's attorney's fees are mandatory and warranted here. For starters, the subpoena itself made no attempt to avoid imposing undue burden or expense. It was a carpet bomb. That's literally the text. No exposition from me. It was a carpet bomb. Kouri demanded all of Katie's communications, regardless of subject matter, with numerous individuals over a 3-year period. She asked for every written or recorded statement from Kouri going back more than 5 years. By its plain language, the request would have included a host of innocuous things, such as Christmas cards, texts wishing Katie a happy birthday, or random and immaterial voicemails. It goes on to say, and Kouri did not stop there. Oh, no, she didn't. Although she should have known they were privileged, Kouri demanded all of Katie's communications with individuals like Todd G, Carrington, Throckmorton, and the attorney Bowman Carter, the attorney Miller, and attorney Skordas. She made sweeping, nearly unilateral requests, such as any and all correspondence. Put another way, oh, please do. Put another way, she plainly asked for every email, letter, text, agreement, and payment between Dr. Gray and any other person for Dr. Gray's entire life. There were multiple similar requests. And of course, Kouri also demanded all documents showing the financial activities of the trust from March 3rd, 2022 to present. Nothing in the subpoena indicates even the slightest measure of restraint, proportionality, or effort to impose an undue burden. Yeah, the subpoena was written like a criminal request for discovery, not a civil subpoena. Request for a hearing filed in the other case comes now. Petitioner Kouri Richins. Remember, this is in the civil cases regarding the estate that are stayed. Petitioner Kouri Richins, through her attorneys and pursuant to rules, requests the court to schedule a hearing in connection with her motion to compel production of trust report information and enforce the May 14th order requiring trust accounting. The case is stayed. The reason for filing the request for hearing at this time is due to the limited time available to obtain a ruling in compliance with any ruling the court may issue prior to Kouri's criminal trial. The information sought likely will have direct impact on the evidence to be presented at Kouri's criminal proceeding. Therefore, it is requested that a hearing for this motion be scheduled within the next 60 days. I really want the judge to just be like, Yeah, this case is stayed. There is a lot of hearings that need to happen before jury selection in this case. And I'm curious to see what the court does. I think with the stayed case, the court's going to say, we're not deciding this. And in the criminal case, the court's going to say, I imagine, these are overbroad subpoenas, but it needs to be heard before the court. And I imagine with regard to the bail bond hearing, that the court's not going to grant a hearing and he's not going to find a change of circumstances. And then he's going to say to the people, I imagine, turn over witness statements, unless that is contrary to what the code says. But the prosecution didn't cite the code. The prosecution said there's nothing exculpatory. I imagine the court will say, can you just give them the witness statement? What are you doing? Give it to them. The motions are going to start to ramp up in the Richins case. When they get put on calendar, I'll let you know so we can cover them. I'm very interested to see how these go. The court does not allow live streaming. So oftentimes we get them on a delay. Oftentimes I will try to tune in and listen so that if we don't get all of the hearings, I at least have a record of what happened in the hearing by taking notes and listening in on the hearing, because I will remember what I hear more than I will remember what I write. So we will see what happens in the Kouri Richins case. We will be covering it at trial, when it goes to trial, unless it gets delayed again, in February. The court took a painstaking amount of time to set forward that hearing. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.